Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. When the United States Navy is sailing around the United States, in other words, they are home ported in places like Charlotte or Portsmouth, San Diego, Seattle, San Francisco, places of that nature, they have access to maintenance facilities here in the United States, and there are private military contractors that are used routinely. But many of our ships are ported in foreign countries, sometimes in Japan, sometimes places like the Philippines. It is sometimes necessary for maintenance to occur at those foreign ports, and for that, the Navy uses private contractors in those countries. And that's what is at issue in this particular case. Well, you know you are in trouble when somebody gives you a name like Fat Leonard. Well, Fat Leonard was a guy in Malaysia who used bribes and influence peddling to essentially cheat the government out of millions of dollars over the course of several years, and may actually have wound up compromising classified information to the Chinese. So there was a lot at stake in a case that went up against 33 separate defendants, including 2 admirals. One of the admirals pleaded guilty, the other admiral was not convicted. But 4 Navy officers were convicted. They're now former Navy officers, were convicted in this bribery scandal, and their attorneys did not quit. They believed that they had some issues with some of the evidence that was presented in the trial, and as a result of that, they continued to push for a new trial, and then when they got some discovery, they realized that they had the wool pulled over their eyes, and they filed a motion for a new trial. So let's take a look at the motion for new trial now. Here is this joint motion. It's filed on behalf of one of the defendants by the name of David Lausman. And basically what it says is they want a new trial. And the reason they want a new trial is because of Brady and Mapu violations. Now, Brady is the Supreme Court case that requires prosecutors to turn over all exculpatory evidence to the defense. And NAPU is the Ninth Circuit version of that takes it a little bit further. The motion is filed jointly by all these folks, and here is what the motion says. The first heading in the table of contents gives you some idea as to where they're going. The government suppressed favorable evidence in violation of Brady and Giglio and presented false evidence. These violations alone or in conjunction with the other constitutional violations compel dismissal or a new trial. So this is the introduction, and this is really all we need to read in this case. A major issue in this case was the source of the documents Leonard Francis and his surrogates provided to the government and whether they were properly authenticated and reliable. Now, authentication means that you have to establish the chain of custody. You have to show how these documents came to be in the possession of the government. And reliability is determined by whether or not those documents have ever been altered or not. And if there is evidence to that fact, then it has to be considered by the jury. Every piece of evidence that gets presented in court has to have a foundation. Just like when you build a house, you have to be able to set the wood and everything else on something, a foundation. Well, in a trial, you have to have foundations for all of your evidence. So, for example, if the documents at issue had been seized in a search warrant, the way you establish the foundation for those documents, you call the person who executed the search warrant to the stand and you say, what were you doing on July 4th? Well, I went to so-and-so's house and I went in and I served a search warrant. When you served the search warrant, what happened? Well, I found a whole bunch of documents. Can you describe the documents that you found? Yes, they're marked here for admission into evidence as exhibits 1 through 19. So documents 1 through 19 are what you seized during the search, yes. And that was subject to a valid search warrant, yes. And this is a copy of the search warrant, yes. And it directed you to seize documents that you found at this location, yes, it did. And with that, you have established and laid the foundation for the documents, and assuming that it doesn't violate any hearsay rule, then what's in those documents can come into evidence in that criminal trial. If that seems like a long and convoluted way to get evidence in front of a jury, it is, but it's also necessary to ensure that bad evidence doesn't get admitted. Hey, if you're enjoying this content, please feel free to like and subscribe. It really helps the channel and makes it possible for me to continue to do this. That's it. That's the commercial. Let's go back and see why the defense was so interested in them having a good foundation for these documents. They say, this court articulated the defense position. I've always known the defense's concern about where the documents came from. How did they get to Covington? Who had access? What was done? The podcast then caused us further concerns based on what Mr. Leonard Francis represented. And we'll get to it more in a minute, but basically what he said on a podcast was that he had anticipated being arrested, and as a result, he had his IT people doctor the evidence that was on the servers for this company that he operated called GDMA. During a motions in limine hearing on February 17, 2022, the court ruled that the government's certification of documents copied from hard drives was inadequate because it did not provide any information about whether or how the hard drives were obtained from GDMA. Mr. Pletcher, who was the senior prosecutor from the Department of Justice, responded that he would solve that problem by calling Esteban Hernandez, a private investigator who worked for Fat Leonard, otherwise known as Mr. Francis in here, who allegedly obtained the hard drives from GDMA's Singapore headquarters. Immediately after that hearing, Mr. Pletcher and Agent De La Pena contacted Francis's counsel and Mr. Hernandez to gather the relevant information and solve their foundation problem. What they learned within the next week, however, was that Mr. Hernandez did not obtain the hard drives from GDMA's headquarters in Singapore. Instead, he obtained them from Richard Ng, GDMA's information technology manager in Malaysia, under circumstances that still remain unclear, at least to defense counsel. The government did not provide this information to defense counsel or the court, however, and defense counsel first learned about it from government-produced discovery 2 weeks ago. The government's problems with the Covington exhibits were compounded early in the trial when the defendants introduced a recording of Francis telling journalist Tom Wright that he'd anticipated his arrest and thus doctored evidence on GDMA's server with the help of his IT people. In light of this development, and after learning that Hernandez obtained the hard drives from Francis's IT manager, the government was undoubtedly loath to call Mr. Hernandez at trial. Instead, the government called Agent De La Pena to lay the foundation for the evidence of the hard drives. Defense counsel objected to this and pointed out that Mr. Pletcher, the senior prosecutor here, represented during the in limine hearing that he would call Mr. Hernandez. But Pletcher falsely told the court that he never promised to call Hernandez for that purpose. Defense counsel were perplexed by this misrepresentation at the time, but now it makes sense in light of the newly produced discovery. The government could not call Mr. Hernandez because he would not be able to lay a proper foundation for the introduction of the documents from the hard drives. And even worse for the government, he received the hard drives in Malaysia from Mr. Ng, the manager of the IT people, who helped Francis doctor evidence on those hard drives. Faced with these problems, Mr. Pletcher lied to the court about having promised to call Mr. Hernandez. Now that's a serious issue. If you are caught on the record lying to the court, you are in a world of trouble because the rules, ABA Rule 3.4, although it's different in California, the prosecutors are still bound by the ABA rules. And the ABA rule says you have a duty of candor to the tribunal. In other words, you can't lie to a judge, and if you lie to a judge, you can be suspended or disbarred, particularly in a serious case. Now, unfortunately, with federal prosecutors, the discipline system never seems to catch up to them. But hopefully it will catch up to Mr. Pletcher, because we're not done detailing the level of his culpability in this, even at this point. When defense counsel cross-examined Agent De La Pena about the source of the Covington hard drives, he also lied, lest defense counsel learn about the government's problems in this context. Among other things, he testified Mr. Hernandez pulled the 9 hard drives from Singapore, disclaimed any knowledge about how this retrieval occurred, and who other than Hernandez, if anyone, was involved, and claimed he could not know what Mr. Hernandez did because it was shielded by attorney-client privilege. None of that was true, and those dates and TT 3628 to 29, those are transcript sites. The recently produced discovery shows that Agent De La Pena had defense counsel and Mr. Hernandez at his beck and call with respect to obtaining this information. He knew that the hard drives were provided by Mr. Ang and the IT manager in Malaysia. As Agent De La Pena gave this false testimony, Mr. Pletcher sat silent and allowed the testimony to go uncorrected, not only to prevent the jury from learning about the evidence that was obviously harmful to the prosecution's case, but also to avoid impeachment of Agent De La Pena, the government's central witness in the case. And basically what that little paragraph means is Agent De La Pena was the one who came to trial and laid the foundation for all of the claims against these defendants. He's the one who set out all of the evidence and became sort of the star witness for the federales here. And as a result, if you basically show that he lied on the stand, you cause significant damage to your case in chief and make it very unlikely that you're going to get a conviction. These events alone warrant vacating the convictions in this case under Napui as well as Brady and the Federal Rule of Criminal Procedure 16. This recently produced discovery adds a mountain of evidence showing that the lead prosecutor, Mr. Pletcher, and the lead agent, De La Pena, were willing to withhold evidence and present false testimony if it believed it would give them an advantage. Given what has occurred, it is impossible to trust either of them or the government's case. Accordingly, either standing alone or when added to the defendant's already filed cumulativeness claim, these new claims warrant vacating the defendant's conviction and the grant of a dismissal or a new trial. What happened, you might ask? On September 6th of this year, the felony convictions of 4 former Navy officers in one of the worst bribery cases in the maritime branch's history were vacated Wednesday due to questions about prosecutorial misconduct. U.S. District Judge Janice Sammartino called the misconduct outrageous and agreed to allow the 4 men to plead guilty to a misdemeanor and pay a $100 fine each. The surprising turn came in a case at a sentencing hearing in federal court. So they'd already been convicted of felonies, and they were set for a sentencing hearing, and instead of having a sentencing hearing, U.S. Attorney Peter Coe, notice it's not Mr. Pletcher. Mr. Pletcher is no longer on this case, who was brought on after the defendants were tried last year, admitted to serious issues with prosecutorial misconduct and asked the judge to vacate the officer's felony convictions. He said his office does not agree with all the allegations, but said errors were made. Anytime somebody uses the passive voice and says errors were made, instead of being honest and saying, Judge, we hid evidence, we screwed up, and I'm sorry, you understand that somebody is trying very, very hard to save a particular lawyer's career. Errors were made. That's an understatement. When you're a prosecutor, you do not have a duty to get a conviction. You have a duty to do justice. That is the hallmark of a prosecutor. You can't be there just to get a conviction because, unfortunately, witnesses lie, Things happen in the case of a trial. Sometimes you don't have the evidence you thought you did. Sometimes the defense is better than you think they can be. And you know what? Sometimes the government loses. And that's a good thing. It's a good thing whenever the government loses, because essentially it proves that the system works. Because if the government won every time, you'd have to really worry about whether the system worked or not. But they used the passive voice here. Mistakes were made in order to downplay the significance of what happened here. And what happened here is you had an unethical federal prosecutor and a deceitful federal agent, and I would say probably a deceitful prosecutor too, because he knew the testimony was false, but he let it go uncorrected. And there is a rule, an ABA rule, that requires you to correct false testimony if it's offered, and you know that it's false. When you're representing the government, you just go in and say, "Judge, I'm sorry, our witness lied." And you take whatever happens as a result of that admission. But that's not what happened. And so this is a pretty serious issue, and one that I think deserves to be looked at by the Department of Justice Inspector General. And I believe that lawyers should be separated from the Department of Justice, and as quickly as humanly possible. And as for the Agent De La Peña, how in the world is he ever going to testify at another trial? He's going to be subject to impeachment. He's basically going to be relegated to being a paper pusher in the Department of Defense somewhere, because he certainly is not going to be a credible witness at any trial in the future. So Andrew Hayden, who is the acting U.S. Attorney for the Southern District of California, reiterated that, as stated in court, we don't agree with all the allegations in the motions. We recognize and regret, however, that errors were made. Again, there's the passive voice. And we have an obligation to ensure fairness and justice. The resolutions of these defendants' cases reflect that. He added that it's significant that the 4 officers who stood before the court today admitted for the first time under oath that they broke the law and are guilty of crimes related to their official duties. Well, gosh, what are these terrible crimes that these officers pleaded guilty to? On Wednesday, 3 of them pleaded guilty to 1 count each of disclosing information, and Lausman pleaded guilty to a charge of destruction of government property for smashing a hard drive. Basically, they all paid a $100 fine, took a conviction for a misdemeanor, and walked away. And that's a pretty good deal for them, and it indicates just how severe this prosecutorial misconduct was, because it essentially indicates that they had no chance of ever bringing this case to fruition. Well, that's what I have for you today. I guess this is another of a lawyers behaving badly case, and I hope you've enjoyed it. I hope it serves as a sort of an example of what kinds of problems erupt in criminal trials when you have prosecutors who are willing to go just far enough to get a conviction instead of playing absolutely fair and square and by the rules. It's a bad deal. If you have the opportunity today, please find some time to do something kind for someone else. Otherwise, thank you for watching and have a marvelous day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.